Welcome back to the lecture series on employee relations and labor laws. Today we will discuss about various provisions under Factories Act. In last lecture we had discussed various provisions regarding welfare of the workers, provisions regarding safety and security of the workers. We have also discussed various provisions regarding health for the workers. Today we will discuss about hazardous processes under Factories Act and what are the provisions regarding hazardous processes. In the terms of law, hazardous processes means any process or activity in relation to an industry where, unless special care is taken, raw materials used therein or the intermediate or finished products, byproducts or waste or effluents thereof would, number 1, cause material impairment to the health of the person or results in pollution to the general environment. All these processes, all those processes are indulged or included in hazardous processes, where the process cause material impairment to the health of the employee or the process result into the pollution to the general environment. Both these situations are included under hazardous processes. Now, this act instructed 2 new schedules, including number 1 is listing the industries involving hazardous processes and relating to permissible levels of certain chemical substances in work environment. Both these schedules are included afterwards in the act. Now, we will start with the provisions regarding hazardous processes. Now, number 1 is constitution of site appraisal committee. This provision says, this section states that the factory should appoint a site appraisal committee which consists of representatives from the fire service department, Department of Environment, a representative of the Central Board for the Prevention and Control of Water Pollution and Director General of Factories, an expert in field of occupational health. These all will be the members of site appraisal committee, and this committee will be responsible for suggesting the location of the factory, which includes hazardous processes. Basically, when we talk about hazardous processes, it includes certain effluents, certain processes which are injurious to the health of workers, or they cause environmental pollution of any kind. So, the main responsibility of site appraisal committee is to find out the appropriate location for the factory where this factory can be situated or the process can be carried on, so that these pollutions or hazardous issues can be taken care of. The next is compulsory disclosure of information. The occupier of every factory involving a hazardous process shall disclose in the prescribed manner all information regarding dangers and the measures to overcome the same. Also lay down the detailed policy with respect to health and safety of the workers and on-site emergency plan. So, as and when occupier will go to the registration process or they have to get the license from the authorities, they have to disclose all the information regarding the process they are carrying on, what are the dangers involved in, and what are the what they are having their policy in respect to health and safety of the workers, and what are their emergency plans on the site. Now, next is specific responsibility of the occupier in relation to hazardous processes. This section states that every occupier of a factory involving any hazardous process should accurately maintain the health and medical records of all the workers in a factory. It is mainly for those workers who are working in the manufacturing of toxic or harmful substances. They have to appoint persons who possess qualifications and experience in handling hazardous substances. Actually, in the case of accidents, So, they have to appoint some of the people who are qualified enough and they have experience in handling hazardous substances to prevent the accidents, or for the accurate action to be taken in the case of any accident held in any factory. Now, next is power of central government to appoint any inquiry committee. Now, this section states that the central government in some extraordinary situations may appoint any inquiry committee for the factories manufacturing hazardous materials. That inquiry, they inquire into the standards of health and safety observed in the factory. They do so to find out the causes of any failure or neglect in the adoption of all measures or standards. Moreover, the committee should consist of a chairman and 2 other members, and the central government determines the tenure of members. Also, the recommendations of committee shall be advisory in nature. Basically, these inquiry committees are appointed to get all the observations related to health and safety measures the factories are using or they are providing for the workers or not. Now, next is emergency standards. This section states that in certain cases, when the central government thinks that the factory is unable to apply certain security measures, then it is allowed to direct the director in charge of the factory to implement the measures or standards on an immediate basis. This is basically in the case of factories where they are unable to apply security measures for the workers. So, to prevent the workers from all the hazards, director in charge of the factories, they have to implement various standards and measures to prevent the workers. Now, next is permissible limits of exposure of chemical and toxic substances. Act provides that the minimum permissible threshold limits of exposure of chemical substances, which should be as per the schedule 2. Also, the central government may at any point of time for the purpose of giving effect to any scientific proof make suitable changes in the SAD schedule. This is basically to provide certain permissible limits to the factories under which they can work in for the chemicals and toxic substances. Now, workers' participation in safety management. As we all know that we do have certain committees within the organizations in the name of works committees or joint management councils, and they have to deal with day to day problems of within the organization, and this is the one of the main responsibility of works committees as they have to participate in safety management of the organization. And this section states that the occupier shall in every factory where a hazardous process takes place should set up a safety committee, and this committee will comprise an equal number of representatives of workers and management to work it out the various issues in safety management and to decide various matters under safety management to provide proper safety and security to the people working within the organization. Now comes the provisions regarding working hours. Now, in this provision we will talk about weekly hours of working or holidays or what are the wages paid to the people to the workers who are working within the organization, what are the paid wages when they have to be all the workers have to be made paid with the wages. All these provisions will be studied in working hours. Now, first is weekly hours. This section lays down the maximum limit on working time for a worker in a factory on a weekly basis. It states that no factory would ask the workers or make them work for more than 48 hours a week. Then weekly holiday. This section states that no adult worker shall be required or allowed to work in a factory on the first day of the week, that is Sunday. That means Sunday will be deemed as holiday for the workers, but if he is required to work on this day, he must have another day as a holiday which should fall within 3 days before or after the first day of the week. Means if any worker they have to work on the weekly holidays, that is Sunday, then they have to be provided one holiday which will be 3 days before or 3 days after of the weekly holiday. Also, a previous notice to employ a worker on Sunday has to be communicated to the chief inspector before the worker is made to work. Means a notice in this regard should be communicated to the chief inspector of the factories before the worker being made work there on Sunday. Such notice also be displayed on the notice boards. This is actually this kind of notice should be displayed in the notice board of the premises to get the workers known about their duty hours on Sunday. Now, compensatory holidays. This section states that if in any case the factory in under any provision cut offs a holiday of the worker, then the factory is under due pressure to give the same number of holidays to the workers within the time period of 2 months. Means if any day where there is a holiday, but workers are have been asked to work on that day, then that does mean that they have to give same number of holidays to the workers as compensatory holidays within the period of 2 months. Now, daily hours of working, this section is nothing but the extension of section 51, keeping in view the weekly working hours limit prescribed by section 51. This section states that the limit on a daily working hours, it states that a factory should allow a worker to work for more than 9 hours per day. That means, the 9 hours per day is fixed for workers to work within the organization. More than 9 hours is not permissible under the Act. Now, comes the intervals for rest. Actually, this Act provides rest periods or rest pauses to the workers also, and the section states that the maximum time for which a worker will work before the interval time period is 5 hours. The interval needs to be of maximum half an hour. Means of every working of every 5 hours of working, the worker will be given a half an hour of break from the work, half an hour of break. Now, next is spread over. Looking at the human limitations in working, this section states that the periods of work of an adult worker in a factory, including the intervals for rest, should not spread over more than 10.5 hours in any day. Means in every 5 hours of working, they will be given half an hour of work, half an hour of rest pause, and then again for 5 hours they can work, and then they will given again rest pause of half an hour. So, including all the intervals and all the working time, it should be not more than 10.5 hours in any day. Next is night shifts. Whenever a worker works on a night shift which extends beyond midnight, his weekly or compensatory holiday for 24 consecutive hours begin when his shift ends. Also, the following day for him shall be deemed to be period of 24 hours beginning when such shift ends, and the hours he has worked after midnight shall be counted in the previous day. Means if the workers are working in the night shifts and they have worked beyond the midnight, so their weekly holiday or their holiday will start after the shift is over. If it is more than 10.5 hours for any reason, the shift will be deemed as the holiday will be starting after the shift ends. Next is overtime and extra wages. This section rewards those workers who are trying to work for more than the maximum time limit. It states that those workers who work for more than 9 hours a day or 48 hours weekly, he is entitled to be paid a double wage rate than the ordinary wage rate of the extra time. Actually, this is about overtime wages, which we will discuss in the Minimum Wages Act, where it provides, the act provides that as and when workers are working for overtime, they will be given overtime wages, and which are double the ordinary wages they are getting. Next is double employment. This section states that no worker is allowed or required to work for more than one factory in a day. In other words, if the worker is working in a factory on any day, then he cannot work for another factory on the same time. This is basically to prevent the double employment and to provide employment opportunities for everyone within the providing employment to everyone. Next is notice of periods of work for adults. This section states that the factory manager should paste a notice on the wall of the factory about the time period of the work for the workers. Means when we talk about notice of period of work, this means various shifts within the organization. They are people are working within the organization in different shifts. So, these shifts should be clearly defined in the notice, and that notice should be pasted in the premises of the industry or factory for the reference of the workers. Moreover, the manager has to comply with the time limiting sections like section 52 in case the workers do not have to work at the same time, then or any changes in schedules, the manager should specify the timings of their work. Basically, this is to set various shifts in order, and to prevent certain workers such as women workers or young people or children working within the organization. So, to prevent them in the odd hours of working. So, it is basically provided what they have to do is they have to specify the time or the hours where they have when they have to work in the organization, and if there is any change in the schedules of the work, it should also be mentioned in the notice, which is pasted in the factory premises. Now, register of workers. Now, basically this is about taking all the records and registers prepared and maintained well in the organization. So, what this section state is that the manager of the factory to maintain a register about the details of the workers of a factory, and these details includes name of workers, work nature, what kind of work they are doing, the specific formal groups of the workers, where in which groups they are working, and moreover no worker can work in the factory unless his or her name is given in the register. That means, all the workers who are working in the organization or in the factory, they should have their names in the registers, and only those, this is basically to provide the security to the workers. Now, comes the provisions regarding annual leave with wages. Now, first is annual leave with wages. Every worker who has worked for a period of 240 days or more in a factory during a calendar year shall be allowed during the subsequent calendar year leave with wages for a number of days calculated at the rate of, if the worker is an adult. So, for that the calculation will be for every 20 days of work performed by him during the previous calendar year, and if a child, 1 day for every 15 days of work performed by him during the previous calendar year. And calendar year, as I had told you in last lecture, that calendar year is starting from January to December, and annual leave with wages will be paid on the basis of 20 days work performed by the adult worker in the previous calendar year. He will be given annual leave with wages, and in case of child it will be 15 days instead of 20 days. Here 20 days and here 15 days, right. Next is wages during leave period. For the leave allowed to him under section 78 or 79, as the case may be, a worker shall be entitled to wage at a rate equal to the daily average of his total full time earnings for the days on which he actually worked. means what wages you will pay for the leave period, the normal rate of daily wages, whatever the worker is earning from the organization, he will be paid the same rate during the leave period. Then comes the payment in advances in certain cases. A worker who has been allowed leave for not less than 4 days in the case of an adult and 5 days in the case of child, means 4 days if the worker is adult and 5 days if he is a child, before his leave begins be paid the wages due for the period of the leave allowed. Means we are talking about the wages during the leave period. It says that it should be paid before the period of leave is started. Mode of recovery of unpaid wages. If there is any sum which has to be paid by the employer and it is due, right, then it will be paid under the provisions of Payment of Wages Act 1936. It says any sum required to be paid by an employer if remains unpaid shall be recoverable as delayed wages under the provisions of Payment of Wages Act 1936. Means they will be treated as delayed wages. Now, power to make rules. As we all know, any appropriate government whosoever is having authority in the organization of factory, they will make the rules directing managers of factories to keep registers containing such particulars as may be prescribed and requiring the registers to be made available for examination by inspectors. Now, employment of young children. A child who has not completed his 14th year of age is prohibited from working in any factory under any circumstances whatsoever. No exemption even in case of emergency can be allowed to overcome the provisions of this section. This section basically says that anybody who is less than 14 years cannot work in the in any kind of factories. It is the duty of the employer to ascertain the age of the children whom he allows to work in his factory. Also, he cannot depend on the statement of the applicant. For that purpose, we have certifying surgeons in the factories who certify that the fitness of the child, of the worker, and he will certify the age also in his certificate. So, for that the employer has to obtain certificate of fitness, and this certificate of fitness is granted by a certifying surgeon on the application of a young person or his guardian, and the application must be accompanied by a document signed by the manager of a factory, and the young person will be employed therein if certified to be fit for work in a factory. Now, working hours for children. No child can be employed or permitted to work in any factory for more than 4.5 hours in any day. As we have already studied that in case of adult workers it will be 9 hours, right. So, in the case of child workers it will be 4.5 hours. During the night, a period of at least 12 consecutive hours including the interval between 10 p.m. to 6 a.m. means between 10 p.m. to 6 a.m. no child workers are allowed to work in the factory. The period of work of all children employed in a factory shall be limited to 2 shifts. Now, comes the offences. What kind of offences in a factory they are encountering, and what are the measure to overcome all these offences. A court can take cognizance of the offence only when the complaint is made within 3 months of the date on which the alleged commission of the offence came into knowledge of the inspector. This is actually time limit for the complaint within the in the court of law. But where the offence consists of disobeying a written order made by an inspector, complaint may be made within 6 months of the commission of the offence. Now, what are the penalties in case of offences? Now, first is penalty for the contravention of provisions relating to hazardous processes. If there is any contravention in the factories of hazardous processes, he will be punished for imprisonment for 2 years or 1 lakh rupees or both. Next is penalty for obstructing inspector. If any factory or any occupier of factory obstruct inspectors of factories in any process they carrying on in case of any accident or any mishappening, then they will be held for imprisonment of 6 months or rupees 10,000 or both. Penalty for wrongfully disclosing results of analysis, it will be 6 months or rupees 10,000 or both. Penalty relating to casing of new machines, if new machines are not cased properly, then 6 months, 10,000 rupees or both. Penalties for offences by workers and parents, fine which may extend up to rupees 500. Penalty for offence by medical practitioner, if a medical practitioner has issued a false certificate of fitness, then he will be penalized with 2 months of imprisonment or 10,000 rupees or both. Penalty for employing child labour, so in that case parents or guardian can be penalized with the fine of rupees 1,000 rupees. Now, major allied provisions under Factories Act. First is power to declare different departments at different factories. The state government has a power to declare different departments of a factory as different factories. It can also do its own or on application on this behalf by the occupier. Moreover, it can declare 2 or more different factories as a single factory. It is generally done on the conditions as the government deems fit. Next is power to exempt during a public emergency. Firstly, public emergency is a grave emergency whereby the security of India or any part of the territory thereof is under threat. In any case of the public emergency, the state government may by notification in the official gazette exempt any factories or class of description of factories from all or any of the provisions of this act. Next is licensing, approval and registration of factories. Previous permission in writing of the state government of the chief inspector to be obtained for the site on which the factory is to be situated or for the construction or extension of any factory or class or description of factories, prescribing the nature of such plans and specifications, requiring for the purpose of considering applications for such permission the submission of plans and specifications, and all after submission of all the specifications and plans, the occupier can get license and approval from the inspector of factories. Now, next is a notice by the occupier. The occupier shall at least 15 days before the begins to occupy or use any premises as a factory send to the chief inspector a written notice containing name and situation of the factory, name and address of the occupier, name and address of the owner of the premises or building, and under section 93. Notice by the occupier, it continues the address on which communication relating to factory, the nature of the manufacturing process carried on, the total horsepower installed means power, and the number of workers likely to be employed, average number of workers per day employed. Then comes the certifying surgeon. As I had told you that a state government may appoint qualified medical practitioner to be certifying surgeon for the purpose of he can approve, he can I mean for the purpose of taking fitness certificates, they will be appointed by the state governments, and no person shall be appointed to be or authorized to exercise powers of a certifying surgeon other than him. Now, duties: examination and certification of young persons, examination of persons engaged in factory in such dangerous occupations, exercising such medical supervision as may be prescribed for any factory or class or description of factories where cases of illness have occurred which is reasonably to be believed are due to the nature of manufacturing process carried on or other conditions of work prevailing therein, by reasons of any changes in the manufacturing process carried on or in the by reason of in the substances used therein, or by reason of the adoption of new manufacturing process or of any new substances for use in the manufacturing process, and also for the young persons are if they are or are about to be employed in any work which likely to be cause to cause injury to their health. For all these processes, certifying surgeons are there to certify various issues relating to occupational diseases, to provide fitness certificates to the young persons, and to provide medical supervision and examination of the people working within the organization. Thank you so much.